Doctrine of Indoor Management is an exception to the doctrine of the constructive notice, and the rationale on which the doctrine of indoor management is founded is justice and convenience. Because doctrine of constructive notice is very harsh with respect to the third person, with respect to the outsider who deal with the company, and just to give the relief to the justice that person, the doctrine of indoor management has been evolved. Now, the best example or the best case or the classical case is Royal British Bank versus Torquent, where the court itself has decided that if any activity to which the outsider does not have any access, outsider cannot know that thing because that is the internal proceeding. So the outsider will assume that all the internal proceeding would be done in its due course. There is no illegality in respect to that. And the activities to which the doors are closed, that is not in the open space, the constructive notice cannot be extended, and those activities would be covered under the doctrine of indoor management, and the benefit will goes to the outsider. See, here we have to understand this thing, that when doctrine of constructive notice is applied, it is in favor of the company. When the doctrine of indoor management is applied, it is in favor of this company. And these two cases that we are going to discuss now will open your mind that how these doctrines are practically important for the company and the outsider, because at the same time stake of the outsider and the company are on the uh, were in the dispute. Now the first case I'm taking, and that is Freeman. I just want to share the screen with you also. Freeman and Lockyer, these two persons versus Bookhurst Park Properties Mangal Limited. See the facts of this case. The facts of this case are similar, that there were two persons. These two persons, H and K, and K was a property developer. So this, these are the brief form. The actual name are different. So the two person in which one was the property developer, he combined with the another person to obtain the certain property, and then they form a limited company. So two person form the limited company, and each took the half of the share capital. These two person were in the board of director, and the memorandum and the articles of the association has been duly submitted because that is requirement. In the articles of the association of the company, there was a clause, and that was that a managing director can be appointed. But in fact, none was appointed as a managing director, but one of them, K, was acted as a managing director of the company, but he was not having express authority, because as per articles of the association, if the board of director, through the resolution, they can appoint any director as a managing director. But actually there was no resolution, but one of them acted ostensibly. He shows the authority that he is the managing director. He was doing like that, and this person in that capacity, or as a showing managing director, he finding a purchaser of estate and engaged a firm. So this firm, there you see here, uh, a firm of architect and surveyor, and handled the application for planning commission. The architect and the surveyor, then after completing their work, they demanded their fee. When it was the question of the fees, there the real controversy arises. And the controversy was that there was no express authority with the person who show himself as the managing director. And as per the articles of the association, the managing director can do that activity. So here the court, relying on the decision of the Royal British Bank versus Torquay, held that where article conferred the power to appoint the managing director, so outsider only is supposed to read the articles of the association. That articles of association is saying that a managing director can be appointed. How he may be aware that actually an person is appointed as a managing director or not? So outsider, like in the Torquent case, that for the outsider it will be presumed that the requirement, the internal that proceeding has been completed, and the person acts as purported as the managing director, though he was not formally appointed as the director. So here there is, this person shows him. And so the concept of the holding out we discuss in the the partnership. So here it is well established that all persons dealing with the company are affected with the constructive notice of its memorandum and articles, but are not affected by any irregularity which may take place in the company's regular management. To the outsider will consider that regular management activity has been done, because for that he has no access for them. For that in particular information, the doors are always closed. And the court stated that K here, the person who shows this surveyor and architect firm as the managing director ostensibly, or he has the shown the apparent authority acting as a managing director of the company, and the board of director also having the knowledge that this person is showing himself as the managing director. So that was their duty also to stop that person. And so the concept of the holding out, so the concept of the holding out is like estoppel. If a person is showing ostensibly is showing an authority, and the person affect, like in the partnership we discuss, if a person is showing that he is the partners in a partnership firm, eh, and the partnership is the firm is also not objecting or allowing, then this person cannot deny that he is not that holding out concept. So similarly here court is saying that by holding out, because K acted as a ostensible managing director and the board of director also has not stopped it, though they have the knowledge. And so as per or as according to the doctrine of holding out of the holding out, the company could not escape now the liability to pay the fee of the architect and surveyor, that firm. Further, that K appoint architect and surveyor was within the ostensible authority of the managing director of the company, and K had not entered into an unusual transaction. Okay, and so with the Torquent rule, because it is the concept of the indoor management and the holding out, the court has to justify that the doctrine of the constructive notice will not apply, and the indoor management and the holding out will give relief to the outsider. Now see this case that have shared to your screen. Here there are the judgments given by the different judges. You have to read the judgment by the uh, just give me 1 minute so that I can find that. Not the Pearson, it's the Diplock judge. If you read the Diplock learned judge judgment, it's nicely written. You will understand how he has distinguished between the actual authority and the ostensible authority. The actual authority would be if this person, through the resolution of the director, acting as a managing director, and apparent ostensible authority he is actually showing, but he was not allowed. So here this Diplock learned judge, the first para and the second para, you read, an actual authority is legal relationship between principal and agent created by consensual agreement to which they alone are the parties. Its scope is to be ascertained by applying ordinary principle of construction of contract, including any proper implication. Then after reading this para, on the third para there is difference between apparent and ostensible authority. And then the fourth para also about showing. And after that, in this next para, in applying the law, here it was the application of all those discussion, that in applying the law, as I have endeavored to summarize, is to the case where principal is not a natural person but fictitious person, like the corporation. Two further factors arising the legal characteristics of corporation have to be borne in mind. First, that the capacity of corporation is limited by its constitution in case of company incorporated by Companies Act, by its memorandum and articles of association. The second is that the corporation cannot do any act, and that includes making a representation except through agent. Under the doctrine of ultra vires, the limitation of capacity of corporation by its constitution do any act in absolute, this effect the rule of apparent authority to the agent. So you have to read this para properly, and then to the next para also. So the judgment given by Pearson learned judge, the judgment by Wilmer, no need to read that. Only the Diplock learned judge read this judgment. It's on perfectly on the valid point, even covering the difference between apparent authority and the ostensible authority, and in the corporation how it has to work. Then in case of memorandum, the doctrine of ultra vires, how it will work. In case of articles of association, constructing notice as an exception, then as an exception the indoor management. So this you have to read it. Okay, now come to the next case. The next case is the name of this case is Kotla Venkata Swamy versus Chinta Ramamurthy, AIR 1934, Madras 579. See, this case is simple, and I expect that you guys will give the answer of the discussion. There was a company. See the facts of this case. First, I have to make this case here. There was a company, and this company name was South Indian Agricultural and Industrial Improvement Company Limited. So this company has executed a mortgage bond. This company, the name of the company South Indian Agricultural and Industrial Improvement Limited, a company, नाम भी ज़्यादा important नहीं है, a company executed a mortgage bond with a particular person, Venkatamma, of the 1000 rupees. Now, who can execute? Because here the earlier case, that how the Diplock judge is saying that who bind the company or having the authority to bind the company by making this type of the thing. In the article 15 of the articles of the association of the company provides that all debt, hundage, check, certificate and other instruments shall be signed by the managing director, the secretary and working director. So 3 persons are required. This is written in the articles of association itself. That is a public document, can be accessed. अंडर सेक्शन 399 ऑफ द कंपनीज एक्ट कि कोई भी जो आपका डॉक्यूमेंट है, डेट, हुंडी, चेक, सर्टिफिकेट, इंस्ट्रूमेंट, दैट हैज़ टू बी साइन बाय मैनेजिंग डायरेक्टर, ओके, देन आपका सेक्रेटरी एंड वर्किंग डायरेक्टर. And in this case, and then it would be considered as valid. In this case, this mortgage deed that was executed on behalf of the company, in this mortgage deed the sign it was signed by only working director and the secretary. There was no signature of the managing director. Then when the company went into the voluntary liquidation, it sold this mortgage right has been transferred to the defendant. And then the question arose that whether the company was bound by or validly executed this mortgage deed or not. Now the question is before you. You have to give the answer. The arguments slightly I have made. The argument in favor of the document, or in case of the company is liable, is that since this thing is written in the articles of the association itself, in article 15, that the company will bind or the document will be valid only when that document has to be signed by 3 persons: managing director, secretary and working director. But this particular document has not been signed by these 3 persons, rather only 2 persons, working director and the secretary. Managing director signature is not there. The arguments from the defendant side, when this was the case in the earlier jurisdiction, original jurisdiction, that the argument by the third person, that since this is something in the knowledge of the company, and so indoor management has to be applied, and it has to be seen that there is default on in the company, and how the outsider know that who are the person who has to sign the document. They in the bona fide knowing the company through the officer get it signed and executed this mortgage bond, and now company is saying that it is not valid. Now you have to decide that whether that mortgage bond would be valid and company would be liable, or it would not be liable. Yes, Abhishek. Kanika. Nitu. Please give me answer. Yes, please speak.
सर कंस्ट्रक्टिव नोटिस लगेगा क्या इस पे?
I am asking, you have to tell me yes or no, whether it is correct or not. We will discuss. Don't worry.
Sir, I am not able to comprehend, sir, right now.
Okay, no issue. At least at one side you can go. Yes, any other person would like to answer it? See, in this case the constructive notice would apply, because who can bind the company is already written in the articles of the association. As I said, that article 15 of the articles of association says that deed, hundai, check, certificate and other instruments shall be signed by managing director, secretary of the company and working director on behalf of the company, and then it shall be considered valid. So it is not the indoor management question. If the question was that the person who signed as a managing director, whether he was actually managing director or not, that would be the internal matter. But when there is the requirement of these 3 persons to validly bind, और जब आप डिप्लोक जज का वो जब जजमेंट पढ़ोगे उसमें ब्यूटीफुली हर पैरा में है कि for the corporation, to bind a corporation, one need to act through these document or according to these documents. And so here the matter to which we are saying have the constructive notice or not, किसी भी मैटर जिसकी नॉलेज होनी चाहिए या नहीं होनी चाहिए, that we have to see in light of the fact that whether that document is public document or is the internal matter or internal proceeding or the internal management of the company. This is written in the articles of the association, duly filed before the registrar, available in the registrar office. Anyone can get the access and can find it. So it is not the internal matter. So the doctrine of constructive notice will apply and doctrine of indoor management would not apply. Doctrine of indoor management would apply if the working director या secretary or managing director, if any person ostensibly show that he is the managing director, has signed it, then we can say that how the third person come to know that the person who show him the managing director एंड द अदर पर्सन वर्किंग डायरेक्टर एंड द सेक्रेटरी, उन्होंने भी उसको अलाउ किया, उन्होंने भी नहीं कहा कि भाई ये मैनेजिंग डायरेक्टर नहीं है. In that case, indoor management will be applicable. But here, the doctrine of constructive notice will be applicable. So this difference, very small difference you have to see. Two things you have to see. The first is, क्या वो डॉक्यूमेंट पब्लिक डोमेन में है, आर्टिकल्स ऑफ एसोसिएशन का पोर्शन है. इफ यस, लगा दो कंस्ट्रक्टिव नोटिस. ओके. द सेकंड थिंग, क्या वो जो प्रोसीडिंग्स की बात हो रही है, जो इरेगुलरिटी है, क्या वो प्रोसीडिंग्स इंटरनल मैटर है या वो पब्लिक डोमेन में है. अगर पब्लिक डोमेन में तो कंस्ट्रक्टिव नोटिस. अगर इंटरनल मैनेजमेंट का है तो रॉयल ब्रिटिश बैंक में क्या कहा कि आउटसाइडर तो यही प्रज्यूम करेगा कि सारी इंटरनल प्रोसीडिंग हुई है, एंड सो उस केस में आपको कंस्ट्रक्टिव नोटिस ना लगा के इंडोर मैनेजमेंट लगाना है. ओके. So with this two cases, we have discussed the doctrine of indoor management, and these three cases, that Royal British Bank versus Torquent, Freeman Lockyer versus this Bookhurst Park Properties Mangal Limited, and the third one is this Kotla Venkataswamy versus Chintya Ramamurthy. We have discussed the doctrine of indoor management.